We're set here today on a motion for new trial filed by you, Attorney Patino, on behalf of your client, Mr. Green.
Your Honor, this trial was held on October 30th of 2025 in your court, and there was a final order that was entered on February 24th of 2026. The motion for new trial was filed on or about March 24th of 2026, which makes it timely within that 30-day time frame that we are required to file this. In addition to that, the arguments that are going to be presented to the court today would show that the ruling that was made and entered on February 24th of 2026 is legally and factually insufficient in order for the court to have made a just and right division of the property. And I would like to start my argument presenting the following grounds for that argument, Your Honor.
The tension in this courtroom begins to build almost immediately. What may seem like a routine motion for a new trial is quickly revealed to be something far more complex and potentially explosive. Attorney Patino is not just questioning a minor procedural issue. He's directly challenging the legal and factual foundation of the judge's original ruling. That's a bold move. In legal terms, arguing that a decision is both legally and factually insufficient is essentially claiming the court got it wrong on every level that matters. If proven, it could completely unravel the original judgment and force the court to start over. The stakes here are massive because what's on the line isn't just property, it's credibility, fairness, and the integrity of the entire proceeding.
You may proceed. Is part of your opening?
No, Your Honor, I'm done with my opening.
Okay, let me move over to Attorney Mitchell. Would you like to make an opening?
Yes.
Okay, you may proceed, Attorney Patino.
Yes, Your Honor. The first argument I'd like to present to the court has to do with Texas Family Code Section 7.009. There was a claim for constructive and actual fraud on the community in the actual pleadings, and there was a portion of testimony that was presented concerning the tax fraud that Mr. Green was convicted of by the IRS, and he did some prison time, federal prison time, for about a year. Well, under the code, the court has to make a specific finding that there was fraud on the actual community in this in order for the court to even consider that in making a just and right division in the divorce proceeding and in the community funds. In this situation, there was not an actual finding in the final decree of divorce of any kind of fraud, even though it was brought up and was implied in the actual proceeding. In order for the court to find that someone has committed fraud upon the community, there has to be a finding that there was a transfer, a gifting, or unaccounted community funds in the actual marriage that was actually made by one person and distributed community funds that were not basically without knowledge or consent of the other spouse. In this situation, none of that occurred because the actual fraud that occurred was with the tax situation for the business that Mr. Green was actually involved in. So the only fraud that occurred was tax fraud directly with the IRS that didn't involve the community or disposing or gifting or transferring of any community assets. In addition to that, the actual lien on the community is just for Mr. Green's portion of his community property division. As the court knows, we have been working on getting the lien release on this, and the IRS is only interested in Mr. Green paying restitution and taking his 30% of what was awarded to him in the divorce. So it didn't affect any of the interest or community portion of Miss Green's in this. So if the court did base their decision on awarding a disproportionate.
Now the narrative takes a sharp and dramatic turn. The mention of IRS tax fraud and actual prison time instantly changes how this case is perceived. But here's where it gets legally fascinating. Attorney Patino is drawing a very precise distinction. He's arguing that while Mr. Green may have committed tax fraud, that wrongdoing had nothing to do with the marital assets or the shared financial community between spouses. In other words, just because a crime occurred doesn't automatically mean it should influence how property is divided in a divorce. This is a critical legal line. If the court blurred that line in its original ruling, it could mean the entire division of assets was improperly influenced by factors that legally shouldn't have been considered at all.
Share based on any allegation of fraud, it was not met per the statute I just quoted. My second argument is that per Texas Family Code 7.008, in dividing the estate in a divorce, the court may consider tax obligations. In this situation, I am going to cite Bacchus versus Bacchus. That is Bacchus, and it's 808 Southwest 2nd 694. And this is the appellate court in Beaumont, 1991, and there was no writ on this. And I'm going to quote that case, which says tax consequences stemming from the division of property as well as any unpaid tax liabilities are proper factors to be considered by the court in deriving at a fair and just division and division of community properties. Furthermore, it is reversible error for a court to refuse to consider tax liability, particularly when it is a substantial and one of the spouses is without means to pay the obligation. In this situation, the court awarded Mr. Green 30% of the estate. Basically, it was 30% of the equity minus some mortgage payments that were awarded to be deducted, a 2020 BMW vehicle, his personal property, and a non-existent IRA and 401k. There was testimony that the alleged IRA didn't exist. It was a savings account that had money in it that had already been spent. So essentially, Mr. Green was awarded just equity in the marital residence. Ms. Green was awarded the majority of the assets. She was awarded 100% of her 401k, which had over $600,000 in it. She was awarded the rent house, which was valued at probably over $350,000. The values on that are not sure. There wasn't a lot of testimony presented concerning the values of those properties, and the marital residence, which is also worth about $350,000, in addition to vehicles, her personal property, and the majority of any tax liability was awarded to Mr. Green. So in this situation, the court awarded Mr. Green a very little amount of the assets in order to be able to pay the substantial amount of tax debt, which is over close to $2 million in the tax debt that Mr. Green was.
This is where the situation becomes truly staggering. A nearly $2 million tax debt, and yet Mr. Green is allegedly left with only a fraction of the marital estate to handle it. That imbalance is exactly what Attorney Patino is hammering home. The argument isn't just about fairness, it's about feasibility. How can someone realistically pay off such a massive financial obligation when they've been awarded so little in return? Meanwhile, the opposing party retains the majority of high-value assets, including retirement funds and real estate. If these claims hold up, this could point to a deeply disproportionate division, one that may not meet the legal standard of being just and right. And in family law, that standard is everything.
Ordered to pay in restitution for the tax fraud. In addition to that, the $30,000 that resulted from a joint filing of tax returns that were filed by Mr. Green, including his spouse, in the situation. So the disproportionate share and the division of property gave Mr. Green very little in order to be able to pay the tax liabilities that he has in this court. In addition, there is another case I'd like to cite, Richardson versus Richardson, 424 Southwest 3rd 691, El Paso Appellate Court, 2014, and there was no petition on this one. There's a two-pronged test to determine whether the court abuses discretion. Number one, did the trial court have sufficient information upon which to exercise discretion on a division of property and debt? And 2, did the trial court abuse its discretion by making a property division that was manifestly unfair or unjust? In this situation, the court did not have current information on anything that was actually divided. There was not any appraisals done for the marital residence located on Valentino Way, and there was not an appraisal on the rental property that was awarded to Miss Green. The only thing that was presented was a tax appraisal, property appraisal from 2024 for the Valentino property. The 401k information for Ms. Green was from June of 2025. That was the 401k statement that was presented. The trial was in October of 2025. The inventory and appraisements were entered into court, but without any supporting documentation as to where the values of anything that was listed on there was given. The court actually asked Ms. Green if she had current information on her 401k, which she did not at the time. She only had what was presented to the court, which was a June 2025 statement. In addition to that, there was nothing presented regarding this non-existent IRA or 401k that Mr. Green was awarded. And there was very little that was presenting concerning the debts that were actually awarded to Mr. Green, other than the tax liability and the supposed tax returns that were filed that were never presented to the court, as far as the $30,000 that he was awarded that he had to pay. So the court made decisions on outdated information and insufficient information because very little was presented to the court regarding what was divided. In addition to that, the court awarded that Miss Green would be reimbursed for mortgage payments from August 2023 to, I believe, October of 2025. And per Texas Family Code Section 3.409, non-reimbursable claims include living expenses of a spouse. So a mortgage payment would be considered a living expense. So the fact that the court awarded Miss Green reimbursement on mortgage payments that, 1, are considered living expenses, 2,
you're out of time.
Thank you, Your Honor.
You're welcome. Attorney Mitchell?
Judge, before I begin, I would like to first point out the fact that there's been no findings of fact, and no conclusions of law. So the basis by which this court has made their decision is unclear. And when there are no findings of fact and conclusions of law, the Supreme Court has held that the court must presume the trial court made all findings necessary to support the judgment. Judge, before we had this trial, we both attorneys had to attend an exhibits conference. We entered all of our exhibits into the court's record. We stipulated to which exhibits.
Now we're seeing another critical weakness being exposed: the reliability of the evidence itself. The court's original decision may have been based on outdated, incomplete, or unsupported financial data, and that's a serious problem. In cases involving property division, especially when hundreds of thousands or even millions of dollars are at stake, precision matters. Current valuations, verified documents, and accurate financial disclosures are essential. Without them, the entire foundation of the ruling becomes shaky. If the judge made decisions based on stale or insufficient information, it raises a powerful question. Was the outcome truly informed? Or fundamentally flawed?
We entered which exhibits will not. Before we actually came to trial, we exchanged both discovery, we exchanged inventories and appraisals, which included all supporting documentation that was necessary, that's required in inventory and appraisement. So both parties were made very well aware of the size and the amount of community estate, and that was also presented to the court through the evidence that was presented and actually entered into the court's record. Opposing counsel goes on to say that, I'm sorry, I'll go back. Trial courts have been given a wide discretion in determining what is considered a just and right division under the Texas Family Code. Opposing counsel goes on to make these claims that there's been a claim of fraud, and going through the record that's been presented as Exhibit 1 in this case. Fraud was mentioned a total of 16 times throughout this record, and 9 of those times was mentioned by Mr. Green's attorney when he was asking my client about whether or not her putting her mom or using her mom as a beneficiary in her 401k was considered a breach of her fiduciary duty and committing fraud. There has been no findings of fraud. My client did not, her testimony was not based on fraud. There's been no actual finding that this court's made this decision in dividing the community estate based on fraud. Opposing counsel cited Backus v. Backus with regard to the division of property, but the opposing counsel didn't bring up the fact that there are certain Murph factors that are considered, have to be considered in determining whether or not there should be an unequal division of the community estate. And that all goes back to whether or not the court made any findings with regard to whether or not there was fraud, whether or not that support the court's decision. And in this particular case, opposing counsel did not file any findings of fact and conclusions of law. So we have no basis by which this court made their decision. And because we have no basis by which the court made this decision, the court is inclined, in the appellate court, the Supreme Court is inclined to presume that the court made its decision based upon the evidence and the implied findings. So at this point, we're asking the court to just deny this particular motion for new trial. We're asking the court to find that this motion for new trial was frivolous, was not based on any factors, that the evidence was legally and factually sufficient to support the disproportionate division of the property, and to find that the division was just and right in accordance with the Texas Family Code.
Thank you, counsel. Well, Attorney Patino is out of time. Did you need to close, or was that it? Okay. The court will deny the motion for new trial.
Thank you, Your Honor.
Thank you all.
And just like that, the motion is denied. Despite the intense arguments, the detailed legal challenges, and the high financial stakes, the court ultimately stands by its original decision. But what makes this outcome so compelling is how it was reached. The opposing counsel strategically pointed out a critical procedural gap: the absence of formal findings of fact and conclusions of law. Without those, appellate courts are often forced to assume the trial court acted correctly. That single procedural detail may have sealed the fate of this motion. In the end, this case highlights a powerful lesson. Courtroom battles aren't just won on arguments alone, but on procedure, timing, and precision. One missed step can outweigh even the strongest claims. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.